Welcome to the deep dive.
Yeah.
Our goal here is always to pull out the really essential knowledge from sometimes dense sources and make complex stuff clear and engaging for you.
That's the plan.
Today we're tackling something pretty crucial if you're involved with patents at all. It's Section 2143 of Chapter 2100 in the MPEP.
The Manual of Patent Examining Procedure, yeah.
Think of this as our guided tour through how the USPTO thinks about a really fundamental part of patentability.
Exactly. And this deep dive is actually part of an ongoing educational series we're doing on the MPEP.
Yay.
Yeah, we're breaking down Chapter 2100, that's the one on patentability, and today we're really zooming in on Section 2143.
Okay.
So for patent professionals, students hitting the books for exams, really anyone who needs to understand how the USPTO decides if an invention is, well, obvious, this section is absolutely key.
Right.
It sets out the basic requirements for what's called a prima facie case of obviousness under the law, 35 U.S.C. Section 103.
Okay. Prima facie case of obviousness sounds like the examiner's first step, their initial argument.
It is. It's their opening position.
So our mission for this deep dive is to really get a handle on what the MPEP says are the basic requirements for setting up that initial case. The argument that an invention isn't patentable because it would have been obvious to someone skilled in the field. And we know this section incorporates changes after that big Supreme Court case, KSR v. Teleflex, right? So there's more emphasis now on like solid reasoning.
That's absolutely right. Before KSR, the thinking on obviousness was often, let's say, a bit more rigid. There was this teaching suggestion motivation test, the TSM test.
I remember that.
KSR really broadened things out, brought in more flexibility, maybe a bit more common sense, you could say.
Okay.
And MPEP 2143 reflects that shift. It guides examiners on how they need to articulate a clear, factually supported rationale when they make an obviousness rejection. So yeah, understanding those core requirements is what we're aiming for today.
All right, let's dive in then. What's the absolute bedrock principle we need to get from 2143?
The most fundamental thing is this. Any obviousness rejection has to clearly explain why. Why the claimed invention would have been obvious to a posita.
Posita person having ordinary skill in the art. Got it.
Exactly. It's just not enough for an examiner to say, hey, look, here's reference A, here's reference B. They have similar pieces.
Right. Can't just point.
No.
Yeah.
They have to spell out the logical steps, the reasoning that would lead a skilled person, that posita, to actually arrive at the invention being claimed.
So it's not just the ingredients were on the shelf, but here's why a skilled chef would have thought to combine these ingredients in this particular way.
That's a great analogy.
Yeah.
Precisely. And to help structure that reasoning, MPEP 2143 actually lists 7 example rationales. They're consistent with KSR.
Examples.
It's not, a completely exhaustive list, but they give very concrete ways an examiner can build that prima facie case.
Let's unpack some of those. What's a really common one? A frequent flyer for obviousness rejections.
Oh, definitely the first one. Combining known elements using known methods to yield predictable results.
Okay, makes sense.
Think about it. You take parts that already exist, you put them together using standard techniques, and the result is, well, exactly what you'd expect.
No surprises.
No surprises. Just the sum of the parts working as anticipated. That strongly suggests obviousness. So strategically, if you're facing that rejection...
You'd want to show something unexpected, right?
Exactly. You need to highlight some synergy, some result that goes beyond what was predictable based on the individual pieces.
Like your bicycle frame and water bottle holder example earlier. Bolting it on is predictable, but maybe the way it's bolted on unexpectedly makes the bike faster or something.
Precisely. Some unforeseen benefit. Okay, what's another key rationale?
Hit me.
Substituting known elements for similar ones. So you have an existing gadget, it uses component X. The invention just swaps out X for component Y, which is also well known and does basically the same job.
Like swapping one standard type of resistor for another in a circuit, and the circuit just keeps doing its thing.
You got it. If the function is equivalent and known, it's likely obvious. Now, if you're fighting this...
You'd argue the substitution wasn't so simple, or maybe it led to some subtle but important difference.
Yes, exactly. Show non-obvious advantages, unexpected functional changes, even if the parts seem similar at first glance.
Okay. What else is on the list?
Then there's applying a known technique to improve a similar device, product, or process.
So using a known method in a known way on a known thing.
Pretty much. Taking an established method, applying it straightforwardly to enhance something similar, and getting the expected improvement, like using that standard waterproofing spray on a regular jacket.
Right. Technique's known, jacket type is known, better water resistance is the predictable outcome.
Exactly. If you're arguing against this one, you'd maybe focus on how applying the technique wasn't straightforward in this specific context, or maybe it produced results way better than anyone would have predicted.
Unexpectedly good waterproofing, maybe. Okay, that's three. You mentioned a fourth.
Yes, selecting from a finite number of predictable options. This often gets called obvious to try.
Ah, obvious to try. Heard that phrase.
The MPEP points to some cases here, like in Wertheim, in Hoxima. The main idea is it's not just any trial and error. For it to be obvious to try, the possible choices need to be, well, limited and sort of known.
Finite and predictable options.
Right. And crucially, there has to be a reasonable expectation that trying those options would actually work. It's not like exploring totally uncharted territory with no map.
So it needs a reasonable chance of success, not just a wild guess.
Precisely. So if an examiner says obvious to try, you might argue back that the options weren't really limited or predictable, or maybe that success was actually pretty unlikely.
Okay, that makes sense.
Yeah.
Now you said MPEP 2143 uses court cases to illustrate these points. Let's talk about Anderson's Black Rock. What's the big lesson there?
Anderson's Black Rock is, a really foundational Supreme Court case here. The invention was basically just sticking a known road paving machine together with a known heater.
Two known things combined.
Right. And the court basically said, look, putting these two known things together didn't create anything new or unexpected. Each part just did its known job, side by side, no synergy, no surprising improvement.
Just predictable results again.
Exactly. It's the classic example. Combining known elements, getting only the expected sum of their functions. That's likely obvious. A key takeaway.
So just bolting A onto B isn't inventive if A just does A's job and B just does B's job next to it. How does Crocs VITC contrast with that?
Crocs is a great counterpoint. Federal Circuit case. There, the court found the footwear claim non-obvious.
Even though foam shoes weren't entirely new.
Well, yes, elements like the foam material and some design features might have existed separately, but the specific combination in the Crocs shoe led to unexpected benefits. Things like unusual comfort, better slip resistance than expected.
Okay, so there was a surprise upside.
Yes, and what's really interesting is that the court found evidence that the prior art actually taught away from combining those specific things. It suggested that combination wouldn't work well or wasn't a good idea.
Oh, wow. So the existing knowledge actually pointed in the opposite direction.
Exactly. So Crocs highlights two powerful arguments against obviousness: unexpected results and prior art teaching away from the combination.
That's a huge difference from Anderson's Black Rock. In Crocs, you got more than the sum of the parts, plus the prior art didn't really lead you there.
You nailed it. Now, the MPEP also mentions a couple of other cases, in Omeprazole, patent litigation, and Ecolab v. FMC. We don't have the nitty-gritty details here, but based on what we've discussed, what kind of scenarios do you think they might illustrate?
Well, following the pattern from Anderson's and Crocs, I'd guess these other cases probably show more examples. Maybe one where, like Anderson's, there was just a predictable combination, so it was obvious. And maybe another where, like Crocs, there was something unexpected or no clear reason to combine things, making it non-obvious.
That's a very logical inference.
They likely just reinforce that core idea, right?
Okay.
That you can't just find the pieces scattered in the prior art and declare victory for obviousness.
Absolutely. You're hitting the nail on the head. All these cases together drive home a critical point. Just finding the individual elements of a claim in different prior art references is not enough. It doesn't automatically make the invention obvious.
Okay, so finding the puzzle pieces isn't sufficient. What else does the examiner need to show, according to MPEP 2143, to make that solid prima facie case?
They have to establish two more crucial things. First, they need to articulate why. Why would a PSETA, a person skilled in that field, have been motivated to combine or modify those specific prior art teachings in the way the claim describes?
Motivation. What problem were they trying to solve? What goal were they pursuing that would lead them down that path?
Exactly. What was the recognized need or issue that would naturally point a skilled person towards that specific combination or modification using those specific pieces of prior art?
Okay, so the why combined, what's the second thing?
Second, the examiner has to clearly explain why that PSETA would have had a reasonable expectation of success. Why would they have thought that putting those things together or making that change would actually work and achieve the desired outcome predictably?
Reasonable expectation of success. So back to Anderson's. Black Rock motivation was clear, pave, and heat at once. Success was expected. Pretty predictable outcome.
Right.
But in Crocs, the motivation to combine those things that way wasn't so clear, maybe even discouraged, and the level of comfort and slip resistance wasn't necessarily expected.
That sums it up perfectly. And underpinning all of this, we have to remember the Graham v. John Deere factors.
The foundation of obviousness analysis.
Always. The obviousness determination requires those careful factual findings. Scope and content of the prior art, differences between the art and the claims, and the level of ordinary skill in the field. You can't build a sound obviousness rejection without that solid factual groundwork.
So for anyone listening, whether you're drafting applications, fighting rejections, or maybe looking at challenging a patent's validity, really understanding these MPEP 2143 requirements is, well, it's non-negotiable, isn't it?
Absolutely critical. It dictates how the USPTO approaches obviousness, which in turn dictates how you need to build your arguments for patentability, focusing on non-obviousness.
You need to be ready to explain why your invention isn't just a predictable mix and match, or why a skilled person wouldn't have been motivated to go down that specific path.
That's the core of it. Articulating that something more, that unexpected result, or that lack of clear motivation or predictability, that's often the key to navigating obviousness successfully.
This has been incredibly helpful, really clarifying Section 2143. Before we wrap up, we definitely want to give a special thanks to Mike Shepard.
Yes, our creative director. Thanks, Mike.
And, of course, the necessary disclaimer. Please remember, this summary was put together using AI tools like ChatGPT and Notebook LM. We try hard to be accurate, but errors or omissions are possible.
Okay.
This is for general educational and informational purposes only. It's absolutely not legal advice or a substitute for proper formal instruction.
Crucially, yeah. For authoritative guidance, you always need to consult the official MPEP itself, or talk to a qualified instructor or a registered patent practitioner.
Couldn't agree more. So just to quickly recap the big takeaways.
Sure. MPEP 2143 demands clear, articulated reasoning for obviousness. Examiners must explain the motivation to combine prior art and the reasonable expectation of predictable success.
Right. And simply finding the claim elements scattered in the prior art, not enough.
Not enough. Cases like Anderson's BlackRock show the obviousness of predictable combinations, while Crocs shows non-obviousness when you have unexpected results or teachings away.
Yeah.
It's all built on those Graham factual findings.
Okay. And now, as we always like to do, a final thought for you, our listener, to mull over.
Take a moment and think about a specific technology or maybe a patent, fairly well. How do these principles we've just discussed, predictable results, motivation to combine, from MPP 2143, and the cases, how do they apply there?
Yeah, what is it in that specific context that truly makes a combination more than the sum of its parts in the eyes of the USPTO? What elevates it beyond the predictable? That's your homework from this deep dive. Thanks for joining us.